Are there any valid reasons for not putting a house you own into a living revocable trust? Really depends on how you own it outside of the trust first. So some states, North Carolina is not one of them, but some states have a unique ownership for married spouses that is terminated by putting a house into a trust. That's called tenants by the entireties. And North Carolina basically allows that tenants by the entireties to be maintained in the trust. Some states, putting the house in trust severs the tenancy by the entireties. The entireties asset is sort of a liability protection against claims of an individual spouse, creditor claims, judgments, those sort of things. And so that's a pretty important protection in the event that, only one spouse gets in financial or legal trouble. It can protect the marital home from being attached to or liened against by the creditor. If the state that you live in, and again, this isn't the case in North Carolina, if the state that you live in basically severs or terminates the entirety's ownership by placing that house in the trust, then that's a good reason not to put it in the trust. There can also be, other valid reasons. That's probably the most common or most important. You could also have it in some other ownership capacity that you don't want controlled by the terms of the trust. Like it could be owned with rights to survivorship to a co-owner that's not your spouse, like another family member, maybe a parent. Then you wouldn't want to put a house in the trust or your ownership interest in the house in the trust.